Hello and good afternoon. My name is Bret Cohen and welcome everyone to today's presentation on 3 new policies issued by OSHA, the Centers for Medicare and Medicaid Services, CMS, scheduled to go in effect in January 2022, and the subsequent legal challenges and accommodations that all employers will be faced with. This has developed into a widespread issue for employers, and Nelson Mullins is a leader in providing COVID-related responses to employers, and we're here to help. We have approximately 150 people signed up for today's meeting, and we will get started. Next slide, please. Again, my name is Bret Cohen. I'm the chair of Nelson Mullins Labor and Employment Practice Group, as well as the co-chair of the Trade Secret Mobility Group at Nelson Mullins. I will serve as the moderator today. Allow me to introduce all of our panelists at once. First, I'd like to introduce you to my Denver, Colorado partners, Chris Eby and Colin Barnacle. Chris is a partner in our Denver office, specializing in labor and employment litigation and counseling. Chris's practice centers around wage and hour compliance and litigation, restricted covenants, labor issues before the National Labor Relations Board, as well as advising emerging companies in the technology and blockchain space. Colin, also a partner in our Denver office, specializes in labor and employment training, counseling, and litigation. Colin's practice spans all facets of labor and employment and he's a regular trainer and speaker on issues ranging from conducting internal investigations, sexual harassment prevention, and other key labor and employment topics. Next, you'll hear from Kristin Ahr. Kristin is a partner in our firm's West Palm Beach office, where she's practiced for 26 years. She's a member, of course, of our employment practice group, and she is the National Healthcare Litigation and Compliance Team chair. Thereafter, you'll hear from Ginger Berry Board. Ginger is the office managing partner of the firm's Tallahassee, Florida office. She has statewide litigation practice representing employers in all sorts of matters, including employment discrimination, harassment, and retaliation. Next, you'll hear from my colleague and partner, Rachel, is a partner in the firm's Columbia, South Carolina office. She earned her undergraduate degree from Princeton University and her law degree from New York University School of Law. Rachel heads Nelson Mullins' national law and motions practice and regularly appears before state and federal courts all over the country. And finally, you'll hear from our partner, Mitch Boyarsky. Mitch is a labor employment partner in our New York office and handles all aspects of labor employment counseling, litigation, and transactions. With that, I will turn next slide over to Chris and Colin. Before I do that, I apologize. There are 5 topics that we're going to cover. First topic is going to be OSHA's emergency temporary standard, the CMS vaccination requirement, federal contractors and subcontractors, some issues that are presently before the 5th Circuit and throughout the United States, and finally, accommodation in the workplace. And now I will turn this over to my Denver partners, Chris and Colin. Next slide, please.
Thank you, Bret. Really appreciate the intro, and without further ado, let's get into the actual ETS by OSHA. 400 pages, all crammed into 25 minutes. So put on your seatbelt, and we'll get you where you need to go. So quick overview. Obviously, the ETS just came out. The big picture view is any employer with over 100 full or part-time employees has to develop, implement, and enforce a mandatory COVID-19 vaccination policy. So what does that really mean? It means that through that policy, you either have to ensure all employees are fully vaccinated, or if they don't want to, which a lot of people won't, you have to offer them the ability to receive regular testing on a weekly basis in most cases, and to wear a face mask at work. So that's the big picture view of it. The ETS went into effect on November 5th. The first set of compliance dates is December 5th, and then ultimately the testing and the vaccination requirement starts January 4th. Obviously, everybody knows that there's been a 5th Circuit stay, and we have Rachel, who heads up our appellate practice, talking about that and kind of how that implicates things. Next slide, please. So big picture, topics covered. We're going to talk about the ETS, what it means, what it requires. We're going to talk about how to document vaccination status. That's a big question for everybody. Another big area, who pays for the testing? Who pays for the vaccination, who pays for the test, what are the procedures for vaccinations and testing, and when somebody doesn't want to be vaccinated, how do you manage this entire testing process? What's required when an employee tests positive? What are some important exceptions? Interactions with other laws and CBAs. For anybody out there with unionized employees, CBAs need to be reviewed. Obviously, as we've all been dealing with, there are other laws. There's ADA, there's Title VII with religious accommodations. Those all still apply, so we need to think about those. And then ultimately, guidance for preparing compliant policies. That's going to be really important, because if OSHA does any sort of auditing or investigations into your compliance with the ETS, first thing they're going to ask for is your policy. Next slide, please. So what's required? Again, a policy that make sure that your employees are fully vaccinated, or if they're don't want to be vaccinated, a process and procedure for them to undergo weekly testing and to use face coverings in the workplace. Those are the big pieces. Obviously, there are significant nooks and crannies to every bit of this, and every one of those things is going to be discussed by us as well, should go into that policy. But this is a big deal. At the end of the day, there's fines of up to $13,653 per serious violation. So you could have a daily violation of 13 grand a piece, and then willful violations could be $135,000. So OSHA is serious about this, and from what we understand, they're going to be pretty active auditing and investigating complaints and or just doing random audits. Next slide.
At the outset, it's important to note that these rules were adopted through OSHA's emergency temporary standards and not a formal rulemaking procedure. So these standards can remain in effect for 6 months and then will be subject to any changes adopted through formal rulemaking, which will include a notice and comment period. As employers, you should be aware that this is not the last word here, and rather these are the standards we're operating under for the time being, and more will follow. You'll also have the opportunity to participate in a notice and comment period. Next slide, please. One of the primary areas of focus that we've been getting questions on is documenting vaccinations. Employers under the ETS have an affirmative obligation to collect acceptable proof of employee vaccination status. You must treat any employees who do not provide such proof as unvaccinated. In pertinent part, employers are required to maintain a record and roster of every employee's vaccination status. If you've already collected proof of vaccination status before the ETS was announced, you're not required to reevaluate vaccination status, and the regulations permit you to use any prior record, even if it's not listed in the forms of acceptable proof that we'll discuss. However, you're still required to maintain a roster of employee vaccination status and take steps now to gear up for this process. First of all, the number of employees and the location of the employees, your existing HRIS capabilities, your human resources staff, number of employees that are electing to test in lieu of receiving vaccination will all determine the strain that these record-keeping requirements will pose to your HR department and the amount of runway that you'll need to effectuate these record-keeping requirements. However, you should be taking steps now or as soon as possible to make sure that you're prepared to handle the record-keeping obligations under the ETS. Next slide, please. ETS outlines a number of documents that constitute acceptable proof of vaccination status. That could be a record of immunization from a healthcare provider or a pharmacy, a copy of a COVID vaccination record card. That could also be medical records documenting the vaccination or immunization records from public health, state, or tribal immunization information systems. Additionally, the ETS allows any copy of other official documentation that contains the type of vaccination administered, the date or dates of administration, and the name of the healthcare professional or clinic site administering the vaccine. Under very limited circumstances, if an employee is unable to produce records of vaccination, an attestation may be permissible. That attestation should state the vaccination status, that they have lost or are otherwise unable to produce proof of their vaccination status, and a declaration that the statement is true and that they understand that providing false information may subject the employee to criminal penalties. The key point to take away from this is an employee can only submit an attestation in lieu of formal documentation if the employee actually can't produce this information. And with, just by way of example, state registries of vaccination and immunization records, a lot of this information is readily attainable. If you know that an employee is not being truthful in the attestation by saying that these records are not available, the company could be liable for failure to comply with the ETS. It's also important to keep in mind best practices for storing this information, both given its nature as confidential medical information and given the burden that the ETS imposes on employers. So first, we recommend storing these records like any other confidential medical documentation. Keep it in a separate file. Make sure that access to that file is limited to those employees that truly need to know that information. Bear in mind that many states have additional laws that impose requirements for storing medical records, and some states, either pre-COVID or in the wake of COVID vaccination policies, have expressly incorporated immunization records within these statutes. So if you have any questions about that, contact one of us and we'd be happy to walk you through what the laws in the states that you operate in require for record keeping. Additionally, when you're collecting this information, you should avoid asking about any health information that's not directly related to the vaccination status. A request that goes further than just asking for the vaccination status and documentation, for instance, one that goes into why a person chose not to be vaccinated, may constitute a disability-related inquiry. Next slide, please. Under the ETS, both employees and OSHA have the ability to request documentation that you are collecting. Employers have 4 business hours after receiving a request from OSHA to produce their mandatory vaccination policy. Employers must provide all other documentation required by the ETS within the next business day of the request. Employees can also request information related to their own vaccination status and the vaccination status of their entire workforce. Specifically, they can request the aggregate number of vaccinated employees at the workplace, along with the total number of employees at the workplace, giving them the % of vaccinated employees. Employers are required to provide this information by the end of the next business day following these requests. So it is incumbent on all covered employers to have these records immediately accessible so that they can respond either to a request from OSHA or a request from the employee. Additionally, applicable state laws, local orders may also impose record keeping and inspection obligations. Again, if you have any questions about the specific jurisdictions that you operate in, please feel free to reach out to any one of us. Next slide, please.
Thanks, Chris. Yeah, that's awfully generous of OSHA to give 4 hours. All right, so let's talk a little bit about, once you have vaccination, you have people going to be vaccinated. The ETS talks about employers' obligation to provide paid time off for employees to get vaccinated and to recover. So first piece of the puzzle is that you have to give a reasonable time for them to receive each vaccine dose and up to 4 hours of paid time off for the appointment, for travel to and fro, etc. So that's sort of set in stone, the 4 hours of PTO. Where it gets a little tricky is ETS says a reasonable time and paid sick to recover from the side effects. Obviously, the vaccine affects everybody a little bit differently. I extend the time you have to keep these records. Next slide, please.
In addition, the ETS requires unvaccinated employees to wear face masks both while they're indoors and when they're occupying a vehicle for company purposes with another person. The vaccination policies that you implement under the ETS must include this requirement. employees are permitted to remove face coverings or masks in limited circumstances when alone in a room with a closed door, provided the room has floor-to-ceiling walls. And if they're working in a role where a face covering would pose a greater hazard to the employee. Now, the ETS suggests that that would be a very serious risk of injury or death. If an unvaccinated employee raises any concerns regarding wearing face coverings or masks for religious or medical reasons, you should engage in a reasonable accommodation analysis. And our colleague Mitch will be discussing that in a little more detail in a few minutes. Next slide, please. The ETS also outlines standards for dealing with positive COVID cases in the workplace. Regardless of an employee's COVID-19 vaccination status, the employer must immediately remove from the workplace any employee who tests positive for COVID. They're required to exclude that employee from the workplace until they receive a compliant negative test, they meet the return to work criteria under the CDC's isolation guidance, or they receive a recommendation to return to work from a licensed healthcare provider. ETS does not require removal of unvaccinated employees if they have had exposure to someone who has tested positive for COVID. Weekly testing requirements, face covering and mask requirements still remain in full effect. Additionally, it's important to note that these standards provide the minimum amount, the baseline that employers are required to comply with. And employers are encouraged to adopt appropriate protocols for anyone coming into close contact with someone who's been exposed to COVID. So your existing policies or state and local guidance may provide additional color to how you're going to handle someone who's tested positive or who's been exposed to someone who's tested positive. Next slide, please.
Let's talk a little bit about the notice requirements. And important note is every single one of these needs to be done by December 5th. So first off, inform employees about the ETS. Largely, that's going to be through the dissemination of your policy. You know, we're also helping clients prepare sort of a short cover statement that outlines the key features of the policy. You know, and it's a good way to present that information to employees. The second is educate employees about the COVID-19 vaccine. ETS makes it a requirement that the CDC's key things to know about COVID-19 vaccine, which is online, is disseminated to employees either electronically or in print. So that needs to be part of what you're providing to your employees. Reminding employees that they cannot be retaliated against for exercising their rights under the ETS. And, you know, I think that's important because obviously this is a highly charged situation. Vaccines are, you know, unfortunately become part of our daily conversation and political conversations, et cetera. So understanding that, you know, people can't be retaliated against for getting their vaccine, not getting their vaccine, et cetera. Advising employees that knowingly providing false statements can subject them to criminal penalties. I think Chris talked about it earlier, that there is an opportunity for an attestation from employees regarding vaccination status. You know, so providing false statements in that regard is you know, could get them in a lot of trouble. And again, just to highlight it, provide employees a copy of the key things to know about COVID-19 vaccine from the CDC's website. Next slide, please. So what are the exceptions to the ETS? The ETS does not apply to employees who entirely work in a remote way. So if people work from home and do not come into the office, then as long as they remain remote, then they don't have to comply with the vaccine or the testing requirement. Or employees that report to a workplace where there literally are no other people present. I know that is the case for some, not many, but you know, that is a situation that arises. Or who, you know, employees who work exclusively outside. You know, I have a lot of clients in, you know, sort of outdoor heavy duty, you know, manufacturing types of things, and maybe they used to have their initial meeting inside, then everybody would disseminate outside. You know, they're going to start having all those meetings outside, you know, so that the workforce and the workplace is truly outside. So there's things you can do to change, to take advantage of that if you can. And then ultimately, federal contractors and subcontractors and other employees that are, employers that are in the healthcare space, or truly have, federal contractors who work solely on federal contracts. There are other policies and guidance that they need to comply with, which you will hear about by my esteemed colleagues in a little bit. Next slide, please.
The ETS provides the minimum amount that we need to cover here. It does not preempt any laws, orders, ordinances that require face coverings in indoor places, require members of the public to show vaccination status. It does, however, expressly preempt any law, order, or ordinance that purports to limit an employer's ability to require vaccination. If a state, for example, Texas, passes a law that says employers cannot, no law can be passed that restricts the ability to require vaccinations, the ETS preempts it. Nothing in the ETS prevents employers from adopting additional requirements, and employers are encouraged to take a look at their workforce and make appropriate adjustments as needed. Additionally, there's no interference with the ADA or Title VII, especially as it relates to accommodations related to disabilities or sincerely held religious beliefs. Next slide, please. For those of you that have any unionized employees, you should carefully review any collective bargaining agreements and determine how they impact the ETS provisions. Key areas for review include whether the CBA requires the employer to pay for COVID testing, whether the employer is required to provide face coverings to employees at no charge, whether the CBA requires paid time off for employees to get testing, or provides a specific amount of time for employees to recover from COVID-19 after a positive test. In any event, review the CBA, and if you have any questions, we'd be happy to discuss in more detail. Next slide, please.
All right, the section everybody's been waiting for, drafting compliant policies. Obviously, the ETS requires employers to have a written policy on vaccination, testing, face coverings. It's critical that you have it in place by December 5th. As Chris noted, OSHA will give you a whopping 4 hours to provide it upon request. So extreme, considering these fines, you need to get this thing in place really quickly. Key provisions, obviously the vaccination requirement, how it's done, the PTO piece related to that, testing procedures, if you come to the work all the time or sporadically, what is required, what are the acceptable types of tests, etc., and the face covering requirements for those who aren't fully vaccinated, and what the rules are regarding that. Next slide, please. Additionally, I think the policies, as I said, should outline the paid leave for mandatory vaccinations. It should talk about, what you as an employer is going to do for testing. Are you going to pay for testing? Are you going to pay for the time-related testing? Obviously that, requires an analysis of wage and hour law, state wage and hour law, etc. Providing required OSHA documentation regarding vaccinations. Should talk about the record-keeping requirements. And then, identify notice requirements where there is a positive COVID-19 case. There's a lot of other, pieces to this puzzle, and, luckily we have worked really hard to put together something we think really satisfies all of these requirements, and we're happy to talk with you guys further about that. Next slide. All right, so that puts an end to our piece of this puzzle here, and let me take some time to introduce Kristin Ahr. As Bret said, she is in our West Palm Beach office. She sort of specializes in the healthcare space. So she's going to talk a lot about the CMS COVID-19 healthcare vaccination requirements, and I will hand it off to you, Kristin.
Thank you, Colin. Good afternoon, everyone. Today, I'm going to talk about what we're calling the CMS rule. So on the same day that OSHA came out with its ETS for employers of 100 or more, the Centers for Medicaid and Medicare Services, the Department of Health and Human Services subdivision, published what is called an omnibus COVID-19 healthcare staff vaccination requirement, what we'll call the CMS rule. Took effect immediately that day. The CMS rule covers approximately 17 million workers in the healthcare space at about 76,000 healthcare facilities across the country. This has broad reach because a majority of healthcare providers do take government monies from Medicare or Medicaid to render services to patients through that safety net. So CMS explained that it was issuing this rule as an emergency regulation because any delay in implementation would result in additional deaths and serious illness among healthcare frontline workers, staff, patients, and others. Some of the clients that we do have expressed certain concern that this mandate will continue to add additional strain to their workforce when bodies are in short supply to assist with healthcare services. Next slide, please. Who does it cover? So this is a list in alphabetical order, but generally what you really need to know is hospices, hospitals, ambulatory surgery centers, rehabs, clinics. Those are all covered by the CMS rule. Next slide, please. What it doesn't cover is physician offices and assisted living facilities or other certain medical care providers that are also listed here. However, what is interesting to note is that all healthcare providers have been operating under an ETS, which is similar to what Colin and Chris were discussing earlier, issued by OSHA in May for healthcare employers only. So they have started or should have already implemented written policies and procedures that the other employers with 100 or more employees are just now getting involved with. Next slide, please. So what the CMS rule basically does is, in addition to the obligations under the OSHA ETS for healthcare providers, covered entities must establish written policies, including for exemptions, religious and medical, which my colleague Mitch will discuss later. But all staff, both existing and new, at all covered facilities must get a vaccination. There is not a vaccination or testing alternative. All staff at these covered entities must be, quote, fully vaccinated by January 4th, 2022. So this is a pretty big step. The federal government has taken the position that if you are taking our money to pay for healthcare services for Medicare and Medicaid patients, we're going to force you to be vaccinated. The only exception for staff members at a healthcare entity who is covered are individuals who provide services 100% remotely and do not have any contact with patients or other staff, such as a full remote worker. Next slide, please. Again, there are standard exemptions and accommodations for exemptions for medical or religious beliefs and accommodations, which will be discussed later. It's my impression, and I haven't seen anything on this, that perhaps a testing requirement may be a reasonable accommodation if someone is medically or religiously exempt. I haven't seen anything on it. It's just a guess. Next slide. So here's where the teeth are. CMS is going to be sending on-site compliance review teams across the states to check healthcare entities to make sure that they are being compliant, check their record keeping, check their written policies. And these certified facilities are expected to comply with all of the requirements, and they have several remedies for nursing homes, home health agencies, and hospices beginning in 2022. Those penalties can include monetary penalties, denial of payment for past or future services, and even termination from the Medicare and Medicaid programs. For hospitals and other acute and continuing care providers, the remedy termination, which means you can no longer admit or take care of patients that use this safety net and get paid for it. So termination is a last ditch effort, and they will try to do everything they can before they terminate, but those are some pretty big teeth. Last slide. So in anticipation of the legal challenge, CMS said, the supremacy clause of the United States Constitution says that CMS can do this, regardless of what state law says. And if one of the other protocols that we're going to discuss today fits and the exact rule of the CMS rule doesn't apply to you, you still must comply with the OSHA ETS or the federal contractor guidelines. So with that, I know that was covering a lot in a short period of time. If you have any questions, definitely reach out to any of us that are on this panel. And I am going to introduce my colleague, Ginger, from Tallahassee office to discuss the federal contractor mandate. Thank you.
Thank you, Kristin. Good afternoon, everyone. I'm going to talk about the rules that apply to federal contractors at this point. The mechanism for placing mandates on federal contractors and subcontractors is different from the OSHA interim rule that was discussed by Colin and Chris and the CMS rule that was discussed by Kristin. The OSHA and CMS rules were issued by federal agencies. The mandate that applies to federal contractors was not promulgated by an emergency rule issued by a federal agency. The president issued Executive Order 14042, and that's what requires all federal contracts to include a provision that requires compliance with guidance that's published by the Safer Federal Workforce Task Force with regard to COVID vaccinations. The required contract clause specifies that the contractor or subcontractor shall, for the duration of the contract, comply with all guidance for contractor or subcontractor workplace locations published by the task force. These workplace safety protocols apply to all covered contractor employees, including contractor or subcontractor employees in covered contractor workplaces who are not working on a federal government contract or contract-like instrument. So, what does that mean in terms of what employers need to do? Well, on September 24th, the Safer Federal Workforce Task Force issued the guidance referenced in the President's executive order. The published guidance requires, first, that covered contractors, next slide, please. Requires that covered contractors must ensure that all covered contractor employees are fully vaccinated for COVID-19 unless the employee is legally entitled to an accommodation. Employees must show proof of vaccination, and unlike under the ETS that was issued by OSHA, an attestation is not an acceptable form of documentation of somebody's vaccination status. Now, should a federal agency have an urgent mission-critical need for a covered contractor to have a covered contractor employee begin work on a covered contract or work at a covered workplace before they've become fully vaccinated, the agency head does have the discretion to approve an exception for the covered contractor. In those limited exceptions, the covered contractor must ensure that those covered contractor employees do become fully vaccinated within 60 days of beginning work on a covered contract or at a covered workplace, and they must adhere to mask and social distancing requirements. Now, with regard to masking and social distancing, the task force has indicated that in areas of high or substantial community transmission, fully vaccinated people must wear a mask in indoor settings, except for certain limited exceptions. Now, in areas of low or moderate community transmission, fully vaccinated people do not have to wear a mask. Fully vaccinated individuals do not need to physically distance either, regardless of the level of transmission in the area. Individuals who are not fully vaccinated must wear a mask indoors and in certain outdoor settings, regardless of the level of community transmission in that area. Individuals who are not fully vaccinated are also required to socially distance. Finally, covered contractors must designate a specific person or persons to coordinate implementation of and compliance with the task force guidance. And the workplace safety protocols that are detailed herein at the covered work contractor workplaces. Now, the designated person or persons may be the same individuals that are responsible for implementing any additional COVID-19 workplace safety protocols that are required by local, state, or federal law. And their responsibilities to coordinate COVID-19 workplace safety protocols may comprise some or all of their regular duties. Next slide, please. Now, the deadline for compliance for federal contractors has changed. The initial deadline for compliance was December 8th. However, recognizing that there was an inconsistency between the compliance deadlines for federal contractors versus large employers under OSHA and healthcare providers under the CMS rule, the White House extended the deadline for compliance to be consistent with the OSHA and CMS compliance deadlines. Now, a couple of additional notes. The executive order and the task force guidelines do not give employees the option to be tested weekly. We had a client that asked us about that yesterday. The OSHA ETS specifically recognizes that the task force guidelines and the ETS, while implementing different schemes, provide roughly equivalent protection. And so imposing a second set of similar protections on federal contractors is unnecessary. So the OSHA ETS does not apply to the federal contractors. Federal contractors must comply instead with the task force guidelines. And those task force guidelines do not allow for weekly testing. Now, the footnote to that is that if an employee is entitled to an exemption for a sincerely held religious belief, disability, or medical condition, weekly testing may be a possible accommodation, and my colleague Mitch will talk about that in a minute. The other thing I want to note before we
stuck on a webinar for the last hour and audio went to shit. Tell you what, it's nothing I can do. Is it cold? Oh wow, I have a coat on.
So, and my colleague Rachel's going to talk about some of these legal challenges, but at this point, the legal challenges do not uphold or stop the enforcement of the rule or the mandates as they relate.
Real quick. Let me make sure.
So with that, I'm going to hand the webinar off to Rachel to talk about some of the legal challenges.
Thanks, Ginger. Good afternoon. I hope everyone can hear me. I know we've had a little technical difficulties today, unfortunately. Again, my name is Rachel Headley, and I'd like to talk to everyone a little bit now about the litigation that's going on in the courts. So the ETS went into effect on Friday, November 5th, and I'm sure you're not surprised. Let's keep that first slide if we could. And I'm sure you're not surprised to know that already lawsuits have been filed in at least 5 circuit courts of appeal. You may have seen or heard in the news, and as Colin and Kristin touched on earlier, on Saturday, November 6th, the 5th Circuit Court of Appeals entered a stay order. So what's going on with this litigation? How do employers navigate that? That's what I want to talk about. Although really this is very much moment to moment. And so my main takeaway for right now is going to be, keep an eye on that deadline in January, because there's still that deadline. And then let's stay tuned. So for the legal challenges, as I mentioned, already they've been filed in at least these 5 circuit courts of appeals. And this is a unique circumstance where I'm sure there's been a lot of national litigation that public issues that folks have seen, and particularly of the last year or two of the election, that typically went to the district courts. Here you go straight to the appellate court, and that's by statute. When there's a petition challenging an agency ruling, you can properly file that in one of the 12 Circuit Court of Appeals, the 1st through 11th, and then the DC Circuit. So there have been a rash of filings, and in addition to the number of different circuits, many of these circuits have multiple cases filed. So I think there are 5 or 6 within the 6th Circuit, 2 within the 7th Circuit, and so these lawsuits that were filed, who are the plaintiffs? And the plaintiffs are a number of different petitioners. They fall into categories including the biggest category is individual states, and then private employers who would be subject to regulation. In some cases, individual employees who work for companies that would be subject to regulation, industry member organizations, private schools subject to regulation, so a number of different petitioners. In terms of the states that have jumped into these lawsuits, I believe at this point there are 26 states spread across these court cases. And so the challenges are, the primary challenge is that that the petitioners are saying that OSHA did not have the authority to do this. That's not part of its enabling statute, and it didn't have the power. And even if Congress wanted to authorize it, Congress could not delegate this duty to OSHA. So that's the main legal challenge. And some of the petitioners have also just raised more merits-based issues about why they think the statute is or isn't a good idea, why it is or isn't necessary. But a lot of these challenges, of course, are based on the legal issue, which is, did OSHA have the power to do this? And as relief, they're seeking a permanent nationwide injunction against OSHA to stop enforcement. So before I talk about what happened this weekend with the Fifth Circuit, I just want to briefly talk about the legal lottery system. Next slide, please. So the legal lottery system is, and actually even amongst the appellate bar, I think it's a fairly unusual process that's not as well known. There's a judicial panel on multi-district litigation that many of you may be familiar with, likely particularly in the products liability area where there might be lawsuits filed all around the country with regard to a certain particular product, and the cases get consolidated to one district court judge to make any legal rulings. There's a specific statute that provides if there are petitions challenging an agency action that are filed in 2 or more different circuit courts within 10 days after the agency action is effective, then the agency needs to notify the judicial panel, and then the judicial panel shall designate one court of appeals to decide the issues. How do they designate? The mechanics are not as important as the fact that it's random. So it is a random selection process. And once that happens, there's a consolidation order, and all of the cases that are filed get pulled into that one court. And so the different courts that the cases have been filed, all of them were filed. One was actually filed on Thursday. Most of them were filed on Friday, the same day as the regulation went into effect. And they have asked for a permanent injunction, but also in each case, the petitioners have asked for an emergency stay to stop enforcement right now. And then what's happened there is the different circuit courts have dealt with that differently. The Fifth Circuit, which I'm going to talk about in a minute, has acted the most aggressively in terms of timing. The other circuits have asked for briefing, sometimes on a 1-day, 2-day timeline, someday on a week, 2-week timeline. So for example, in the 7th Circuit, there's a position paper due in today. In the 11th Circuit, the OSHA has a response to the motion to stay due at the end of this week, and the petitioner's reply due next week. In the 8th Circuit, the briefing schedule puts this out into December, and there's a motion to expedite that's been filed that there's been no action on as of yet. Next slide, please. So in the case filed in the Fifth Circuit, the original petitioners were a management company, as I mentioned, assorted different petitioners, locally owned supermarkets, 6 individual employees of an HVAC company. Other petitioners joined suit, including the 4 states listed here, Texas, Utah, South Carolina, and Mississippi. An immediate motion for an emergency stay was filed. And on Saturday, the Fifth Circuit entered this stay order, and there's not much to it. It's about 2 sentences long, and I've given you the second of the 2. So this is what they said. Because the petitions give cause to believe there are grave statutory and constitutional issues with the mandate is hereby stayed pending further action by this court. So that was Saturday. Then the Fifth Circuit ordered expedited briefing on the motion for the permanent injunction and directed the OSHA, the government, to put in its response to the request for a permanent injunction by the end of the day on Monday, and for the petitioners to put theirs in by the end of the day yesterday. And so the government's response has been to direct the Fifth Circuit and all the other circuit courts to this legal lottery I mentioned earlier, and point out that they are expecting a consolidation order on November 16th, which would be right at the end of that 10-day period. So the 10 days for all the lawsuits to get filed or get filed, and then they can be consolidated. So the government's position has been, there's this consolidation order coming, basically wait. And the petitioner's reply brief filed late yesterday, in fact, asked the Fifth Circuit to go ahead and rule on the merits to enter a permanent injunction and to do it quickly before that consolidation order could come through.
Hey, Rachel, can I interrupt for a second? So for the lay folks on this call, there are many, what does it mean for employers across the country? So employers that aren't within the Fifth Circuit, say in the First Circuit, like Massachusetts, the Ninth Circuit in California, et cetera, what does it mean?
Okay, good question. And in fact, if we can transition to the next slide, please. I think, I hope this can answer. And initially, an order by the Fifth Circuit, you might have someone in Massachusetts might say, what power does the Fifth Circuit have over me? At this point, the Fifth Circuit's order, individual employers are not defendants or parties to that lawsuit. The defendant to those petitions is OSHA. And so the order is staying OSHA's ability to enforce. And so it says we have entered a nationwide stay. For now, it's just temporary, which means don't anybody do anything until we can resolve the merits. It will move to a next level if they go ahead and actually rule on the merits of the petition, which would be incredibly fast for an appellate process. But what it means is that the regulation itself has not been invalidated. And there is no particular action required, allowed, or anything of individual employers. So in other words, it does not affect the ability of employers to continue doing what they're doing. Employers could voluntarily mandate vaccination, and that's outside of this regulation. And you know, our recommendation at this point is there is a regulation in place. It does have an enforcement deadline, and right now there is no enforcement anyway. So OSHA is not going to come knock on your door tomorrow with a fine because the deadline for enforcement is not here yet. So the best thing to do would be to continue and plan and prepare for that enforcement that's coming, but stay tuned. So when this consolidation order comes, as we expect it will, at this point, I can't say whether the Fifth Circuit will have ruled then, and if so, how will that affect the consolidation order? Ultimately, the issue will likely go to the United States Supreme Court. There are different ways to get there. And so all of this is just going to really just have to unfold over the next few days. But for now, what it means and the takeaway is continue to plan and prepare for that enforcement deadline and stay tuned. And we're going to continue monitoring this very carefully. And with that, I'd like to turn over to my partner, Mitch. He's going to talk some more about accommodations. Thank you.
Hey, Mitch, before you go, I just want to let everybody know that we is monitoring the legal machinations as closely as humanly possible. And if you sign up for our alerts, you'll be the first to know as soon as something changes in connection with what Rachel just presented. So with that said, Mitch, take it away, please.
Thanks, Brett. Thanks, Rachel. One thing to keep in mind about the CMS rule and the emergency temporary standards is that it hasn't changed an employer's obligation to comply with the Americans with Disabilities Act and with Title VII of the Civil Rights Act of 1964. In fact, the ETS basically just says, you know, see Title VII and see the ADA for accommodation obligations. So for anyone who hasn't attended any of our prior webinars, we did one last month actually about the mandate, anticipating this would happen, as well as accommodations. And I'm going to do a little bit of a summary and shorter version of that, because what we've seen more and more is a response by employees seeking accommodations. And so our prior webinar was recorded for anyone who's interested. And we also post on our website called HR Minute, a blog regarding these developments, and specifically something that occurred since our last webinar and I think is relevant to talk about is the EEOC issued yet additional guidance on accommodations regarding religious belief, observance, and practices, such that perhaps there's a little bit more direction for employers about religion. But generally, let's talk about the overarching legal background here, which is the Americans with Disabilities Act Title VII. And for the most part, pre-employment inquiries about an applicant's medical history are unlawful and prohibited by the ADA. About employees, slightly different, but I'll touch on that in a second. For now, I would just say practical advice is I wouldn't ask an applicant about their vaccine status, but you could post what your policy is, and soon you will be posting or deciding at least you're going to have a mandate for vaccine or optional testing. Once an applicant is an employee, then you can discuss vaccine status. Similarly, under the ADA, medical exams are generally unlawful for the same reason. And prior to the vaccine mandate, I would say have a limited exception, which is to require an individual to disclose a medical condition only where it's job-related and consistent with business necessity. But as I'll touch upon in the next slide, that pretty much went out the window. Second, we have an obligation under HIPAA, and there's other state equivalent laws to protect the privacy of employees' medical records and information. And then finally, under the ADA, there's an accommodation obligation, which is really the crux of our focus these days, is how to deal with accommodation requests made for disability. Title VII requires similar accommodation for employees who have a sincerely held religious belief, a practice, or observance. And under both statutes, there's an anti-retaliation provision. And keep in mind, next slide, please, that for the retaliation obligation by employers, right, there is, in addition to Title VII and the ADA, retaliation prohibitions under the ETS and the CMS rule. So it's more the same, but it's a reminder to employers about retaliation. So as I said before, with the ADA, there are limitations on asking employees about medical conditions, medical history, but for the most part, now an employer is entitled to, in fact, under the ETS, required to ask whether an employee is vaccinated. So there's no longer a limitation. There's some limitations, and Colin and Chris were talking about the record-keeping obligations to keep medical records confidential, filed separately, you know, all the normal stuff that you would do with employee medical records, and keeping records of a vaccination. Those same rules apply. Next slide, please. Okay, so this is really where I think we're spending a lot of time, and me personally, I've been helping clients with this. As a general rule under Title VII and most similar state laws, an employer is prohibited from discriminating against an employee because of a sincerely held religious belief, practice, or observance, and is required to accommodate, provided that it doesn't create an undue hardship for the employer. So religion is traditionally what you think: Christianity, Judaism, Islam, Hinduism, Sikhism, Buddhism. But it doesn't require that a employee participate in a congregation, go to church, have a commonly recognized religious belief. In fact, you know, Title VII says, for purposes of religion, it's basically a person's own scheme of things, provided that it's sincere, it's meaningful, and that is basically the equivalent of filing or following a practice that's parallel to the observance of religions for which there is a God. So, you know, how do you navigate this? And up until about November 3rd, I guess, you know, we were left with a little bit harder job, but since then the EOC issued some interpretations or guidance and pretty much said, well, if an individual identifies an objective basis, then for the most part, that's sufficient. There's no methodology, there's no formal words or significant program or practice for identifying the need for religious accommodation, and that triggers an employer's obligation to attempt to accommodate. An employer can do a limited factual inquiry to determine that an employee has a sincerely held religious belief. And what I would suggest is similar to the ADA accommodation methodology and documentation that we use, and for anyone that's worked with me or others in our group, you know, we'll typically have a set of forms where an individual has their certification prepared by their healthcare provider, right, provide what their limitations and abilities are. Well, you can't really do that so much with religious accommodation. In fact, the EEOC says, if someone identifies a religious belief, that as long as it is sincere and we believe that it is sufficient enough to accommodate, that is all that an employer can really ask about. Keep in mind that social, political, philosophical beliefs do not fall into that category, okay? But for sincerely held religious beliefs, it triggers an accommodation obligation, which is to hold a conversation with an employee. And similar to the ADA disability accommodation, I recommend that employers use a form or template to identify what the sincerely held religious belief is, and to ensure that it's practiced, for which the obligation to accommodate exists or is triggered, unless it creates an undue hardship, right? And then next slide, please. And then assuming there's an obligation to accommodate, what does that accommodation consist of? Well, typically for those who can work remotely, it might involve telecommuting, implementing additional safety measures in the workplace, providing PPE. There may be changes to a job responsibility, or maybe scheduling, or maybe hybrid working, to the extent that an individual has to be in person wearing PPE, but to the extent possible, having that individual work outside the workplace or not in close contact with coworkers. So the obligation to accommodate may take a variety of different flavors. Just to give you a sense of some of the questions that I have fielded from clients about the religious accommodation, and there's been a number of them, but one that typically comes up, and keep in mind that I'm giving you an agnostic interpretation of the laws and the regulations. So the accommodation requests that I've more commonly heard, and sometimes clients have even received like form letters. In fact, one client got multiple form letters from the same organization. They just changed the employee's name on it to say that the employee is pro-life, and based upon sincerely held religious belief, they can't be vaccinated because the vaccine contains aborted fetal cells. The answer to that question is no, that it does not. And so again, it still requires the employer to go through the interactive process to understand the sincerely held religious beliefs. But if it's not factually based, that would be an opportunity or reason to deny the accommodation request. And in those cases, it did. So, there's been a number of these types of questions. I suspect that you also, as employers, may deal with some combined requests for accommodations based upon religion and disability, and I've seen those as well. So keep in mind accommodation obligations. I think it was said multiple times previously by my colleagues. I would consult with counsel about this because it is tricky. And more, I suspect that we will see some legal challenges based upon the denial of accommodations. So stay tuned perhaps for more, and maybe more pronouncements by the EEOC and state and local agencies doing the equivalent type of education on the subject. So with that, I'm going to turn it back over to Bret. Bret, all yours.
Thank you. I appreciate that. Excellent job, Mitch. So in the remaining time that we have, which is about 8 minutes, what I'd like to do is go over some of the questions that we received from the audience. Mitch, I'm going to begin with you because you're the last one up, and that is, typically once you receive a religious accommodation request, and then you and the client work through the interactive process you described, and you conclude that, for example, it's not legitimately held because it's factually incorrect for reasons why you said. What's your next advice? What's the advice? Do you keep the employee? What is it that you're recommending, generally speaking?
Sure. Well, first of all, it's going to depend upon the employer's policy. So if it has a mandate, right, there's really not much of a choice. If the employer chooses to allow for testing an option, it may further some additional opportunity for the employee to remain. But if the mandate exists, then if the individual is not entitled to an accommodation, the employee could be excluded from the workplace. And what I would typically do is have the employer provide a written response to deny the request. We've considered your request for the following reasons. We believe that is not sincerely held, or whatever the reason is, so that there is documentation about that, which is maintained, obviously, like a regular employment record. But then if there is a mandate, the employee is excluded. If there's testing opportunities, the employee could undergo testing.
Thank you, Mitch. That's great. This is for Chris and Colin. How do we calculate 100 employees?
Take it, Chris.
Sure. So employees must count all employees across all U.S. locations, regardless of where they perform work. Part-time employees are counted towards the total number of employees. However, independent contractors are not. As always, employers should be careful about independent contractor misclassification, especially if that pushes them over the line here. Although remote employees are exempt from many of the ETS requirements, they are still included in the total employee headcount.
Thank you.
The only other thing I would add to that would be if you have 100 employees, 100 or more on the date of implementation, even if you fall below 100 within the next 6 months, it still applies to you. So don't go firing employees thinking you're going to get out of this. You're stuck.
Thank you, Colin. I think this is also for appropriately addressed to both Chris and Colin. What do you mean by fully vaccinated? What does that mean?
I'll let you start it off, Chris.
Sure. So employees who've completed their primary vaccination by the date, by January 5th, do not need to be tested, even if they have not completed the 2-week incubation period that's typically used to deem someone as fully vaccinated. It does not include booster shots at this time. While booster shots are recommended as directed by healthcare professionals, an employee who's received their full primary dose, either 1 shot of a single dose vaccination or 2 shots of a 2-dose vaccination, are deemed fully vaccinated.
Yeah. So bottom line, I would say is if between now and January 4th, anyone who gets their final shot, whether it's a 1-shot deal or a 2-shot deal, you don't have to do the incubation period. If you start to get your vaccination and you get your final shot after January 4th, then fully vaccinated means after the 2-week period of incubation after the final shot.
Chris and Colin, will over-the-counter home tests satisfy the testing requirements?
So that was part of one of my slides. So these, self-administered tests do not comply with the ETS unless, and actually this is when the audio went out, so I'm glad you asked the question, unless it's proctored. So if you as the employer want to oversee the employee taking that home test, or they come into the office and you literally watch them do it, that's acceptable. Or if you have a telehealth professional who's going to get on a Zoom call and watch you take it and watch the results come up, that's acceptable as well. But you have to have it proctored by a medical health professional or you, the employer.
Thank you. I'm going to direct this one to Mitch, and the question says, for the testing requirement, can we say that everyone needs to be vaccinated and only the people that will be able to do the testing as opposed to the vaccination are those with a medical or religious accommodation?
Yeah, I think that's really consistent with what we have collectively been saying. So in writing, the employer's policy says, what is the program? Are we mandating? Do we give the testing option? And as an exception, right, then we allow individuals to be tested, or otherwise we will follow applicable law, right, where required, which really just means disability and religious accommodations. So I would say that I think it's important to make sure that's in your policy, because I suspect if an employer is audited, there's going to be a potential challenge if it doesn't include that exception or the accommodation opportunity.
And Brett,
Right.
just to jump in on that real quick, recent OSHA FAQs have clarified that you can have different requirements for different classes of employees. The example they give in the FAQs is a department store where you have retail employees who are interacting with the public subject to a mandatory vaccination policy, and then corporate employees can have testing in lieu of because they're not generally interacting with the public, and that's approved under that OSHA FAQ.
Thank you, Chris. Here's an interesting question: does the indoor masking requirement include individuals when they're in their office, their own office space?
Generally speaking, yes, but the ETS makes it clear that they must be alone in the room if they're unvaccinated, and they need to have the door closed and floor to ceiling walls. So you can't sit in a cubicle by yourself, and you can't sit in a shared office if you're unvaccinated and remove the face covering or mask.
Okay, I'm going to direct this. Thank you. I'm going to direct this question to, I believe, Kristin. Are physician offices with contracts with Medicare Advantage plans, do they fall under the federal contractor status?
No, they do not. Physician offices who have federal contracts are not covered under the CMS rule, but if you're talking about they are federal contractors for purposes of outsourcing federal jobs, that would be covered under the federal contractor rule, which Ginger talked about, or OSHA if they have 100 or more employees. But physician offices alone, because it doesn't follow CMS's safety and guidance enforcement scheme, it would not be under the CMS rule, but possibly under the alternative rules, which is why you have to look at a holistic approach at the entire presentation.
Perfect, Kristin. And then before we wrap up, there's a lot more questions that we may not be able to get to. So if we didn't get to your questions, as I see them flooding my inbox here, please feel free to send us an email, and I'll make sure, send it to me, Bret.Cohen@NelsonMullins.com, and I'll make sure the right expert here answers it. But I want Rachel to give some late breaking news on that relates to some of the questions around the current state of play on appeals and what's being challenged. So Rachel.
Excuse me. Thanks, Fred. I can't add a whole lot because this is very much late breaking news. But what I talked about earlier was the challenge to the ETS, and that's what's going on in the federal circuit courts. As far as CMS is concerned, there's been a lawsuit filed, and I'm just looking at it. I haven't read the entire thing. It's about a 60-page complaint, just filed today, possibly in the last couple of hours as we were preparing for this webinar. And it appears that the plaintiffs seem to be, my quick review, is at least the 26 states that are also challenging the OSHA regulation. And the argument is that this is unlawful agency action violating the Administrative Procedures Act, and that the power to impose vaccination mandates is a power reserved to the states. That was filed in the federal district court in the Eastern District of Missouri because it just procedurally it's a little bit different than a petition challenging that agency rule. So that's going to be something that we're going to look at more closely, and glad to answer questions or provide updates as people ask. But that's just happened in the last couple of hours.
Rachel, thank you. And Rachel and I have had significant experience in the Eastern District of Missouri and the 8th Circuit Court of Appeals, haven't we, Rachel?
We have.
Okay, and the last question we'll answer before we thank our panelists is a question that's being asked frequently. Yes, that is a seat behind me from Fenway when it was rehabilitated. So that answers the most important question that we received. That said, I want to thank all my panelists today. I want to thank the audience for staying connected even during some of our technical difficulties. We really appreciate it, and we look forward to staying further connected with everybody. With that, thank you very much and have a great day.
Thanks, everyone.
Bye, everyone.